Welcome back to SCOTUS Oral Arguments and Opinions. In this episode, we'll discuss the June 12th, 2025 Supreme Court opinion in the case called Parrish versus United States, case number 24-275. We'll first walk through the syllabus. Then, we'll discuss what the case means from a practical standpoint. Finally, this episode will compare the oral argument dynamics to the ultimate opinions. Please note that this summary is read by an automated voice. The question presented in this case is whether a litigant who files a notice of appeal after the ordinary appeal period expires must file a second, duplicative notice after the appeal period is reopened. The court held that a litigant need not file a second notice and reversed and remanded the case. Justice Sotomayor delivered the opinion of the court in which Chief Justice Roberts and Justices Alito, Kagan, Kavanaugh, and Barrett joined. Justice Jackson filed an opinion concurring in the judgment in which Justice Thomas joined. Justice Gorsuch filed a dissenting opinion.
Justice Sotomayor's majority opinion, federal inmate Dante Parrish alleges that he was placed in restrictive segregated confinement for 23 months based on his suspected involvement in another inmate's death. After a hearing officer cleared him of wrongdoing, Parrish filed suit in federal district court seeking damages for his time in segregated confinement. The district court dismissed his case on March 23, 2020, holding that some claims were untimely and others unexhausted. When the court's order reached the federal prison 2 weeks later, Parrish was no longer there, having been transferred to a different facility. Parrish received the dismissal order 3 months after it was issued and promptly filed a notice of appeal, explaining his delayed receipt. The Fourth Circuit recognized that Parrish's notice of appeal came well after the 60-day appeal period for suits against the United States, so it construed Parrish's filing as a motion to reopen the time to appeal under 28 U.S.C. Section 2010-7C. On remand, the district court granted reopening for 14 days. Parrish did not file a second notice of appeal, although both Parrish and the United States argued that the original notice of appeal was sufficient. The Fourth Circuit held that Parrish's failure to file a new notice of appeal within the reopened appeal period deprived the court of jurisdiction. Held, a litigant who files a notice of appeal after the original appeal deadline, but before the court grants reopening, need not file a second notice after reopening. The original notice relates forward to the date reopening is granted. A, civil litigants must ordinarily file a notice of appeal within 30 days after entry of judgment, or 60 days when the United States is a party. In civil cases, the requirement to file a timely notice is jurisdictional. Congress created two exceptions. Courts may extend the appeal time upon a showing of excusable neglect or good cause, and courts may reopen the time for appeal when a party entitled to notice does not receive it within 21 days of entry. Here, there is no dispute that the district court properly reopened Parrish's time to appeal. B, Section 2107C, establishes that a reopened appeal period runs for 14 days from the date of entry of the order reopening the time for appeal. A notice filed after that 14-day period is late, meaning it can no longer serve its purpose. A notice filed before reopening is granted, however, is merely early. While the statute's text does not address the jurisdictional consequences of a premature filing, Congress legislates against the background of common law principles, which apply unless a contrary statutory purpose is evident. This court has long held that premature but adequate notices of appeal should relate forward to the entry of the document that makes an appeal possible. For over a century, the court has consistently applied this principle to avoid dismissing appeals based on mere technicalities when no genuine doubt exists about who is appealing, from what judgment, and to which appellate court. The practice with regard to premature notices did not change when Congress passed the first version of what is now 28 U.S.C. Section 2107 in 1948, or when the Federal Rules of Appellate Procedure were subsequently promulgated. The text of Section 2107 CE itself provides no indication that Congress sought to terminate the long-standing relation forward rule or disturb its development. Applying the relation forward rule, Parrish's notice related forward to the date of the district court's reopening order. C. Counter-arguments are unpersuasive. While the word reopen presumes the appeal period has closed, this merely confirms that Parrish's notice was premature with respect to the reopened period. It does not resolve whether the notice should relate forward. The characterization of the notice as late rather than premature fails to recognize that there were two proper times to appeal: the original 60-day period and the 14-day reopening period. The Fourth Circuit's concern that a single filing cannot serve dual purposes is contradicted by precedent recognizing that one document can simultaneously function as both a notice of appeal and other required filings. D. The Federal Rules of Appellate Procedure support this result. Rules 4, A2, and 404 codify the principle that premature notices should relate forward when they do not prejudice opposing parties. The 1993 amendment eliminating restrictions on relation forward was specifically designed to avoid creating a trap for an unsuspecting litigant and to address the problem that many litigants, especially pro se litigants, failed to file the second notice of appeal. Rule 4, a six's silence on relation forward does not create a negative implication prohibiting it, particularly given the rule's emphasis on securing just, speedy, and inexpensive determination of every action or proceeding and disregarding errors and defects that do not affect any party's substantial rights. So long as Rule 4(6) does not speak to relation forward, the default rule applies. That means Parrish's appeal can go forward under the federal rules as well as the statute. Reversed and remanded.
Justice Jackson's opinion concurring in the judgment. I file this concurring opinion because I agree with the court's conclusion that Parrish did not need to file a second notice of appeal. But I reach this result without relying on ripening or relation forward principles. I treat Parrish's filing as a routine motion practice situation that occurs daily in federal district courts. When litigants file motions seeking to reopen or extend deadlines, they typically attach the late document they hope to receive permission to file. The district court then dockets the proposed filing if it grants the motion. I construe Parrish's submission as effectively a motion to reopen with an attached proposed notice of appeal. Once the district court granted reopening, it should have docketed the notice of appeal as what courts do every day when such motions are granted. This approach treats the notice of appeal as coming contingent upon the court's granting the accompanying motion rather than as premature. I find this reasoning makes the case much simpler than the majority's approach. The motion to reopen and the notice of appeal were one and the same document. It would be strange to reopen a case because the litigant filed a proposed notice of appeal, but then failed to treat that filing as a timely notice of appeal. I note this reasoning might not apply in other factual circumstances, such as when a would-be appellant files a notice of appeal and then days later submits a separate motion to reopen. In such cases, courts may need to determine whether the earlier notice relates forward upon granting the separate motion. But here, the factual basis for the decision is much simpler. Parrish's proposed notice should have been docketed as timely filed upon the district court's granting of his motion to reopen.
Justice Gorsuch's dissenting opinion respectfully, I would have dismissed this case as improvidently granted. The Advisory Committee on Appellate Rules has already launched a study to consider whether changes to Federal Rule of Appellate Procedure 406 may be warranted to treat premature notices of appeal as relating forward to the first day of the 14-day window 28 U.S.C. Section 2010-7C prescribes. Surely, too, a change to the rules could have solved the problem presented by this case. Even if Section 2107C requires a notice to be filed during a certain window, the Rules Committee could provide that a premature notice shall be treated as filed at a later date. Already, the committee has done exactly that in other appellate rules, including Rules 4A2 and 4A4. Rather than take up problems the Rules Committee can solve, and has announced its interest in solving, and in doing so, risk the possibility that the committee, understandably, may suspend its own activities and delay their resolution. I believe the wiser and more efficient course is to let the committee get on with its work. That body is charged with reviewing issues of precisely this sort.
Those were the opinions in the Martin case. Let's now turn to case implications. Here are two. First, this decision is a major win for prisoners and other pro-se litigants who often face communication delays that can doom their appeals. Under the Fourth Circuit's rejected approach, an incarcerated person who filed a notice of appeal after missing the deadline, even if they later got permission to reopen their case, would have had to file a second notice within just 14 days of the reopening order. Given how slowly mail moves between courts and prisons, this created an almost impossible hurdle. Many inmates would never even receive the reopening order before their new 14-day window expired. Now, their original notice of appeal will automatically carry forward once reopening is granted, eliminating this procedural trap. Second, this ruling settles a circuit split and creates nationwide uniformity on appeal procedures. Before this decision, whether your appeal survived depended on which federal circuit heard your case. The Fourth Circuit required a second notice of appeal after reopening, while the Sixth and Ninth Circuits did not. This geographical lottery meant identical cases could have opposite outcomes based solely on location. Now, all federal courts must follow the same rule. One notice of appeal is sufficient, and it relates forward to cover the reopened appeal period. This consistency makes the federal court system more predictable and fair for all litigants, regardless of where their case is filed. Next, let's talk oral argument tea leaves. What's fascinating here is how the oral argument revealed the justices wrestling with a seemingly simple question that turned out to have some surprisingly complex layers. Let me walk you through how the different approaches we heard during oral argument ultimately played out in the final opinions. During oral argument, we heard this interesting exchange between Justice Jackson and petitioner's counsel about whether we even need the concept of ripening to solve this case. Justice Jackson kept pushing back, saying, "I'm not sure that ripening is really the best way to think about what is happening here. And why do we even need ripening to get to the result that you are seeking?" Well, it turns out Justice Jackson was on to something. In her concurring opinion, she completely sidesteps the majority's reliance on ripening principles. Instead, she writes, "It is unnecessary to resort to ripening or relation-forward principles to reach that result." She treats this as a routine motion practice situation, explaining that when litigants file motions with attached documents every day in federal court, the district court then dockets the proposed filing if it grants the motion. One of the most compelling moments in oral argument came when Justice Sotomayor highlighted the practical unfairness to prisoners. She pointed out that these litigants already didn't get timely notice to appeal because they didn't get notice within the 30 days. And now, given the way the post office is working, it's unlikely they're going to receive any notice in 14 days. The majority opinion clearly absorbed this concern. Justice Sotomayor, writing for the majority, includes a footnote that reads almost like she's speaking directly from that oral argument moment. Requiring pro-se litigants to refile their appeal after the district court has told them their delay in appealing has been excused is especially likely to lead to confusion. She even uses Parrish's own case as an example, noting that had the reopening order taken as long to reach the prison as the original judgment, the reopened appeal period would have been over before the order granting it arrived. Here's where things get really interesting. During oral argument, the government's attorney actually supported Parrish's position. She argued that filing too early doesn't disrupt finality or risk prejudice to others, and that there's no basis to require a duplicative filing. But then we had this fascinating dynamic where the court appointed an amicus attorney, Michael Houston, to argue the opposite position, essentially to defend the Fourth Circuit's ruling that nobody else wanted to defend. Justice Sotomayor even made a joke about this unusual situation, saying, "I don't think we've ever had an amici come in and say the judgment was wrong." One of the most intriguing threads from oral argument was Justice Gorsuch's repeated suggestions that maybe the Rules Committee should handle this issue instead of the court. He kept pushing this idea, saying things like, maybe leave that to the Rules Committee, and asking whether the Rules Committee might have something profitable to say about how far this relation forward principle might obtain. This becomes the centerpiece of Justice Gorsuch's dissent. He writes, "I would have dismissed this case as improvidently granted because the Advisory Committee on Appellate Rules has already launched a study to consider whether changes to Federal Rule of Appellate Procedure 4(6) may be warranted." He argues the court should have let the committee get on with its work, rather than resolving the issue judicially. During oral argument, there was this back and forth about the legal principle called expressio unius, basically the idea that when a law lists specific things, it impliedly excludes everything else. Chief Justice Roberts and Justice Gorsuch pressed on this, noting that other rules explicitly mention relation forward, while the reopening rule stays silent. The majority opinion tackles this head-on, acknowledging that Rules 4(2) and 4(4) expressly permit relation forward, while Rule 4(6), governing reopening, is silent on the issue. But they reject the negative implication argument, explaining that the context includes not only the background relation forward principle, but also the rule's own emphasis on function over form. There are a few takeaways I had when comparing the oral argument to the decision. What did you notice? That's it for Parrish. Hope you enjoyed. If so, please follow, share, and review. Let's next turn our attention to Soto v. United States.